on roll call. Double click on this roll call. Hey, how are you?
Pretty good.
Voting members, okay?
Good morning, everybody. I'm going to go ahead and call to order the License and Variance Board meeting for Wednesday, July 24, 2019. The time is now 10:02. Running to my left is Scott Andrews, the Assistant City Administrator, and to Scott's left is Frank Martin, our Director of Public Works. In front of Frank and Scott, or Terry Graham, our City Clerk, and Mary Arbin here for the official meeting minutes. We have a couple items on the agenda this morning. The first one that we're going to hear is 3A, variance request V19-025 to allow a 6-foot wooden privacy fence in front yard and corner lot, land lot 330, 0.41 acre, 591 Summer Tree Court for Mr. Zach Wood and Lisa Sysom. Is the applicant present? If you could please step forward. Sir, if you could please step forward to the podium. Our meeting is recorded for the minute, so if you could please speak into the microphone. Thank you.
Good morning. Tokir Chauhan here on behalf of the applicants.
Okay.
And this has actually been was tabled at the last meeting and continued to this morning. And during the interim, I was retained to help see if we could work out a resolution. There are some parties that have objected to the application, and we attempted to have conversations with them to see if a resolution could be reached, but unfortunately there's just hasn't been a meeting of the minds per se on that. And for that reason, Mr. Wood and Ms. Sysom would ask for the board to once again consider their application for the variance for the 6-foot fence.
Right.
And based on the standards of that request for the variance, it is our position in our request that the variance be granted based on the fact that they're at the corner lot and there's a 6-foot fence that surrounds the rest of their property, and they have requested for that 6-foot fence to be allowed for the full property of their backyard. There's privacy concerns, and also just in order to have use of their property. The fence is on their property. It's within their property lines, and our position is that there is no safety concern for that 6-foot fence being allowed, that there's no hazard being posed to the public, and that it is within aesthetics of the neighborhood and the surrounding area. And for that reason, we would request that the variance be granted.
Okay. Right now, are there any questions for the applicant's representation?
No, sir.
Okay.
Thank you.
Mr. Joey Stobbs, if you could, please. So I understand we've been briefed on the fact that this was heard 2 weeks ago, was tabled to today. We also have discussed concerns that were raised from the last time, which was the reason for the tabling.
Yes, sir.
All right, so just as a summation, this board, what's in front of this board is whether or not this fence height can be 6 feet instead of 4 feet.
That's correct.
That's what's in front of this board.
Yes, sir.
However, the city, this board chose to table 2 weeks ago to address some concerns that were raised through public comment.
That's exactly right.
So if you could kind of touch on those things raised and describe to us what the city staff found specifically with regard to those concerns that were raised.
Well, the comment that was made last hearing was that the fence causes visibility issues for pedestrians in the right-of-way walking to the park.
So site distance issues.
Correct.
Okay.
The city engineer is here. They went out with us to inspect the fence and found that there's no impediment to visibility issues for pedestrians.
Okay, so before we move on to anything else, so this kind of is in the realm of the city engineer, right?
Sure.
So Mr. Kevin Moore is here with us today, our city engineer. Mr. Moore, if you could please, so help us to understand the site distance concerns and what you assessed. You were physically went to the site?
Yes, we went out Monday of this week. Ashley White and I, the assistant city engineer, went out with Joey and Rusty from community development just to assess the situation. It was our opinion that granting a variance of 6 feet for this fence would not create a impediment to safety related to pedestrian access or driver access. It's a non-issue in our opinion.
Okay. Any questions for Mr. Moore? Thank you, Mr. Moore. Okay, Mr. Stobbs, were there any other concerns or contemplation in the last 2 weeks from staff about any other issues raised?
From my understanding, that was the issue that we were to explore
Okay.
from that hearing to this hearing. We recommended approval at the original hearing, and our recommendation hasn't changed.
And I was also told there was some discussion about the location of the fence over
The drainage easement.
drainage easement, right? So,
There is a drainage easement sort of along Nickajack, and then it does a diagonal along Summerwood. The main monument sign is over this underground pipe. A portion of the new fence is over that easement.
so
if-
just so I'm tracking,
Yes, sir.
Joey, it's not a ground swell that, that would collect stormwater runoff. It's actually a stormwater pipe
Correct.
under the ground.
And if
and
maintenance was
current-
ever needed, the applicant would have to replace that fence at his expense.
Yeah, right, which is the same thing's true for anything that's over a pipe, a stormwater pipe. And did you say that the current monument sign, the big entrance to the subdivision sign is over the pipe already?
Yes, sir.
Okay. Okay, any questions for Mr. Stobbs?
Joy, the applicant is aware that if the fence does have to come down for any issue due to stormwater, it is his responsibility, and he has to pay to have it put back up.
I mean, you can ask him. He's acknowledged to me.
Any other questions from this board for the staff or the applicant? To the applicant's representation, do you have any other comments that you'd like to make at this time?
No, there's no further comments at this time.
Okay, so this is a public hearing. I would ask if anybody's here to speak on behalf of item 3, I would ask that you would step forward at this time. Correct. If you want to speak in favor of or against this, item 3A, I would ask that you would step forward one at a time at this time. Good morning. If you would, please, for the record, just state your name.
Good morning. My name is Chinita Johnson. I live at 581 Summer Tree Court, which is directly next door to 591 Summer Tree Court. I think at the last meeting they said something about let's get together for a resolution. We live directly next door. No one has come to us and asked us any kind of comment, how can we can resolve this or anything. Now, we live right next door. We've been living there for like 30-some years, and now we have a fence that's there. No one came and asked us, is it, I mean, I know it's their property and everything like that, but somewhere, somehow, it should have been some kind of ask us something about this. I'm kind of nervous because it just makes me a little upset that I'm having to get up here again and speak regarding our home that's directly next door to 591 Summer Tree Court. It's just, to me, I don't know what else to say, is that I oppose it. I'm not in agreement with it. The attorney that they have representing them, that they retain, has not even come next door. And 581 Summer Tree Court, we have not received any kind of letter or anything like that regarding this. So I just want to say that I oppose this fence being built directly to our property at 581 Summer Tree Court, Mapleton, Georgia.
Okay, thank you. Thank you, Ms. Johnson. Anybody else? Again, if you could please state your name for the record.
Thank you. My name is Richard Poland. I live at 4730 Summerwood Drive.
Sorry, could you spell your last name?
Poland.
Thank you.
And I have a presentation I'd like to present to you all, if that's okay.
Okay, is
These
it
are
information
pictures.
that we don't already have?
Yes, it
Okay.
absolutely is. One for each. And I'll start off by thanking you for tabling the issue for 2 weeks so that we could get more information, so that you could get more information. I agree that the continuance was necessary, and it was necessary for a couple of reasons. And what I'm about to point out brings me no satisfaction. I'm not happy to have to do this at all. I've lost sleep over it. I've been emotional about the whole situation. And the people that I'm pointing out in my presentation, and I don't mean to make this personal, but I feel like we've been treated unfairly, and this needs to be brought to your attention, and we need to be treated fairly. Many of the neighbors could not be here in person given the short notice last time, so they made phone calls and sent emails in opposition to the variance. They were under the impression that their voices would be heard by the city planner's office, but they were barely more than a footnote in his presentation. In fact, it was 2 words in the presentation, and that was significant opposition. That's the only thing that was mentioned in the presentation about all the people that called and emailed, and I know there were many people. There's 32 homes in the neighborhood. I know that at least 20 called and emailed about it. Postponing the vote allowed them the time to make plans to be here in person and prepare their remarks. And also, because we were the board, it's a different board, but because the board was presented with virtually no analysis before the hearing, we expected that the city planner would do a thorough job, but realized sadly during the hearing that they hadn't done much analysis at all. In fact, they presented no analysis at all. There was no opinion in the hearing other than the city engineer's opinion that the fence does not create a visibility issue, which we will debate greatly here in a minute. Furthermore, the board, the planner's office, I think they attempted to mislead you, the board, and they misled us, the neighbors of Summer Place. And this extra time gave us time to complete our analysis that we thought the planner's office would do, but they didn't.
Mr. Poland, if I could just interrupt you for a second, and I would just caution you. So basically, when you're talking about staff misleading, unless you have direct physical proof.
I do. I'm about to present it.
I want to just caution you to make sure that you're not speculating just your personal opinion.
I'm not.
So
evidence
I would
presented.
prefer that if we could keep your opposition to things that are directly to the fence and not about staff. Okay, and if you have issues with staff, I'm not telling you that you don't have a voice. I'm just telling you if you're going to make certain allegations, you better just make sure that you have something other than your opinion.
I believe that my presentation will point out that about the whole process. I'm not directly talking about staff because I think that they've been hamstrung in some cases, and overall they've been hamstrung and they're not allowed to, or they've been made almost to be irrelevant in this process.
Okay.
Because it's my understanding that 33 of 33 variances have been passed. So that tells you a lot right there, that there's not a lot of analysis given to this.
Okay. Go ahead, sir.
The way that the staff was misleading in a couple ways, they reported they stated in their presentation to you that the sign that this fence is part of is taller than the fence. I'll show you in photo number 1. You can look. The sign is clearly not taller than the fence. That's a mistake, but it's a misleading mistake because it's obviously not right, and it's I think geared towards just allowing pushing this through quickly. During the hearing, Mr. Stobbs mentioned that the sign ranges in height from 6 to 8 feet tall. It does not range in height from 6 to 8 feet tall. The sign ranges from 3 feet 9 inches to about 6 feet. I didn't take a measurement of the high side. It's a little bit taller than the fence on one side. And you'll see in photo number 2 the measurement of the low side of the fence. Number 3, near the end of the hearing last time, Mr. Stobbs was asked if there are any easements regarding the sign. Who controls the sign? Is the sign wholly controlled by the applicant? His statement was, according to the survey, there's no easements. He did not have a survey when he said that to you. It was misleading in the fact that he was trying to present to the board that he had looked into that issue and had decided that there wasn't an easement. Well, he's already presented to you today that there was. He actually went back and did the work and saw that there is an easement, and the sign is on an easement. My reason to point this out is not to call anybody out. My reason to point this out is that we need to be treated fairly, and we need to be treated in accordance with the laws that are on the books. And I've presented to you the plat. This shows the easement. The pink and yellow highlighters, that shows the 35-foot setback and the 20-foot drainage easement, which the fence is built on. And you can see in photo number 3 that the fence is approximately 32 feet from the road, so it's within the easement and within the setbacks. I called after the hearing. I called Mr. Martin and pointed out these mistakes and asked them to try to rectify this, and I got nowhere. I got the feeling that this was something that they just wanted to go away, and so based on that, I've decided that I had to present this analysis to you. So if you'll
just as an awareness, you got about another minute. I'll be more than willing to let you go just a little bit beyond, but there is a speaking time limit. And also, too, let's keep in focus that what we're contemplating is the height of the fence.
Understand.
Okay.
Understand. I presented to you following in the zoning code, section 1401 of the variant. This is the zoning code regarding the variance petitions. And line B says that the following information must be provided. And you'll look down, I've highlighted number 4, a copy of the plat. A copy of the plat was not provided during the application or during the initial variance hearing. So I guess my question is, do we need to have this? Nobody in the room here is elected official. We don't write the laws. We don't change the laws. If the board members can see their way to apply the laws that are written in the section, the code section, if you can't see a way to do that and apply it to this case, then I think we need to move this case to our elected representatives and ask the city council to hear the request in your place. So I'm asking you, are you all willing to go by the zoning variance code that is written in our city code? Is that something that you are willing to do and apply in this case? Or do we need to move it to the city council?
Okay, so just for the sake of clarification, any decision by this board is appealable to the full council. Okay. So to answer that question, regardless of the decision and the action taken today, that decision is appealable to the full council, and there are. Our Terry Graham can help anybody with that process, just written notice within a certain number of business days. Okay,
then I'll skip through real quickly. If you apply the standards in section 1403, and I'll run through them real quickly for everyone to hear, whether there are unique or special or extraordinary circumstances applying to the property, is the alleged hardship self-created, would strict application of the code deprive the applicant of reasonable use of the property, and whether the variance proposed is the minimum variance needed. I'll go through those quickly and show you that there's no good reason to grant this variance based on the code, based on the standards get provided to you in the code. This is not a unique circumstance. There's not, not everybody lives on a corner lot, but there's a bunch of subdivisions in Smyrna, a bunch of neighborhoods in Smyrna, and I'm sure there's at least 1,000 corner lots. This isn't so unique that when the people that wrote the code didn't dream this scenario so that it shouldn't apply, so that the code shouldn't apply to this scenario, and actually they wrote the code and gave additional restrictions to this scenario. So it's not a unique situation. In fact, right across the street is another house with a mirror image lot of the subject. Same lots, same frontage on the same streets, pretty similar dimensions. They have a fence and they have 4 children, and they have use of their yard. Number 2, is it self-created? It's obviously self-created. He built the fence, he made a mistake, and it's all, it's obviously self-created. Number 3, is he deprived of reasonable use? I printed a photo. It's photo number 4. You'll see that the yard's not really that private anyway. We live on a hill. When you come down the hill, you can see the entire yard anyway. There's a 3-foot 9-inch section of fence, of sign currently that the fence is attached to. That makes the fence, the height of the rest of the fence is irrelevant because if a dog's going to get out, it's going to get out over the 3-foot 9-inch section. That's, I showed you the picture of that earlier. It's also photo number 5. If someone's going to get into the fence, they're going to get in over this section no matter how high the fence is. So the yard's not safer or more secure with a 4-foot fence. And they also could move the fence back if they wanted to, and we've offered to pay $1,000 for them to help them do that. So you're not depriving them of reasonable use by applying the code. So the variance is not needed, so there's no minimum variance needed for number 4. So you have no good reason to say yes to the variance based on the code. If you follow the code, you have no good reason to say yes to the variance. But you do have many reasons to say no. 1, we've made multiple offers through every process. I offered in the very first 2 phone calls to the homeowners, I will help you however I can, financially, physically. I'll do the work. I'll pay for it. We've made offers. If you look further back in the next page, you'll see one of the offers that I made. You'll see the emails to the attorneys, to his attorney that we made. We offered to pay entirely to alter the fence to 4 feet and turn it into a split rail fence, which the neighborhood can get behind. We've offered personally, my wife and I have offered to pay $1,000 for him to keep the 6-foot fence and move it back so that we still have a sight line to the road, which I'll show you in a minute that we don't have now, but we used to have. And so that the fence is he still has a 6-foot fence, which would be more private and more secure, a 6-foot fence all the way around.
We
He's
hate to
balked at all
cut
those
you off, sir,
offers.
but we've far exceeded the time. If you could wrap it up quickly.
I'll do number 2. This, I think, is the most damning evidence that you need, and this is the crux of the purpose that we're here today. If you look at photos number 6 and 7, this is a before and after view of where the fence is now and where it used to be. I asked the city planner's office to do this photo and do this analysis, and they would not do it for me. So I went and I got on Google Maps, and you can see, we used to be able to see all the way up Summerwood Drive to the first street. You can see if Elton's kid is screaming down the hill on a scooter and can't stop. You can see if Sonny and Caleb's kids kick a ball out into the road and it rolls down the hill. You used to be able to see that from Nickajack, and you could stop in plenty of time. That's happened to me. The scooter thing has happened to me once, several years ago. Now all you see is fence. So the visibility is an issue.
Which is, when you talk about public safety issues like that, those are all, nobody's going to say that's not a valid concern, which is exactly why this board chose 2 weeks ago to table so that we could have the experts, the people who are trained and whose job it is to go out and assess whether or not it is or it isn't, right? So, and I can tell you, the photos 6 and 7 that you referenced, they definitely portray exactly what you just said. But in all fairness, sir, and I'm not taking one side or the other, photo 6 was taken when there's no foliage on any of the trees. It looks like it was taken in the fall or the winter. In photo 7, the trees are full of foliage. Photo 7 is also taken from a different angle. Again, this is why that we have the experts that physically go on site so that we can make sure that we do not speculate. Okay, and also the standards that you eloquently read off are standards that every variance has to go by. I am not a city planning expert, and I don't know what you do for a profession, so correct me if I'm wrong, but you probably aren't either. Those standards, I can tell you, don't just sit on a shelf. Those standards are pulled out, and every variance request that comes to this city through this board are measured by those standards, and not in a way just to pass something through for the sake of passing it through, okay?
With all due respect, the experts in this case, they've made their statement. I understand that. There are people that have been living in this subdivision for 30 years. I've been there for 11. We've had people there for a year, 5 years. We've been driving in and out of that subdivision for all that time. And I know what we used to be able to see, and I know what we can see now. And you're about to hear from other people who will say the exact same thing. And I can't recreate Google's exact image, and I can't go back in time and take a picture in the fall to show you what we can see in the fall and what we can see in the summer. We can see through there in the summer. We could see through there in the fall and the winter, and now we can't. That's the bottom line.
Okay.
I have several other reasons for you to say no. I hope that you will read through the rest of the
So-
presentation, but maybe someone else will yield me some of their time. If not, maybe someone else would like to continue my presentation. But otherwise, I hope you can see your way to do the right thing. Follow the code as it's written and not inject your personal opinion, and do the right thing by our neighborhood and say no to this variance. Thank you.
Thank you, Mr. Bowen. Is anybody else that'd like to speak? Hey, good morning. If you could please state your
My
name.
name is Alice Hearn, and I live in this subdivision.
I'm sorry, what was your last name again?
Hearn, H-E-R-N.
Thank you.
The thing that concerns me with the height of the wall is, did they look at the codes? And if they looked at the codes, did they just say, well, I'm not going to worry about them, which is very selfish. But at the end of the day, if you should rule in their favor, does that not set a precedence for the next person who wants an 8, 10, or 12-foot wall to be able to do it? Codes are there for a reason, and I ask you to vote for the codes. Thank you.
Thank you, Ms. Hearn. Is there anybody else that'd like to speak? Good morning. If you could state
My
your
name is Tara Head, and I live at 580 Summer Tree Court, just across the street from the applicants. And I echo in what Alice just said. My main concern is not only in regards to fences, but in the future when other codes are broken and variances are submitted, what is going to be allowed if this is allowed to stand as is. And as she said, the rest of us should not have to suffer by, one, seeing the unsightly fence, and two, risking our property values if they chose not to research this in advance. That's not our fault. If they made the investment without doing any research, the rest of us should not have to suffer for that. Thank you.
Thank you. Good morning.
Morning, Kristen Poland. I live at 4730 Summerwood Drive. I mean, I think we've hashed out the safety concerns, and I just want to be clear that the safety concerns, I know what the experts have said, but I also know what I can see with my own eyes, and what I can no longer see. But I also think that, you know, the property values is another issue and another reason that the codes exist in the first place. And, you know, when you have half a room full of people who say, you know, it is my opinion that this fence, it doesn't look right, and I am afraid it hurts my property values. I mean, I think that that's another valid concern that we have to consider. And you know, as my husband had said, we've made offers as far as modifying the fence, and I don't feel like they were met with much give at all. And it's just kind of disheartening that we've kind of made these offers of time and labor and money, and just to be met with barely anything on the other side as far as compromise goes. I would just ask that, you know, if you do consider granting this variance, that you perhaps consider that it be granted with some conditions. You know, if that's where we're going to go, then I would at least ask there be some conditions placed on that. That conditions being, you know, preferably maybe moving the fence back another 6, 8, 10 feet. That would give, you know, it would contribute to the aesthetics, because you wouldn't have that butted up against the monument sign, which it just doesn't look good. It would give them more security, more privacy. It wouldn't deprive them of any use of their property by doing that. It would kind of just meet everybody's goals. So I would just ask that that be at least considered. So thank you.
Thank you, Ms. Bowen. morning.
Good morning. How's your day?
That's okay.
Good. Ryan Allen, 4721 Summerwood Drive. So I'm not opposed to a fence as long as that fence is within code. When I purchased my house a little over 2 years ago, I bought it with the understanding that there were codes in the city of Smyrna, which is why I chose to live in Smyrna and not somewhere else. And as the code as written is my expectation is that it's enforced. And currently the fence in question does not meet code. So I would hope that you would deny it.
Thank you, sir. Anybody else? Good morning, sir.
Good morning. Ryan Roy, 621 Summer Tree Court.
And your last name again?
Roy, R-O-Y.
Thank you.
You're welcome.
That's my first name. Hey.
That's your first name?
Yeah.
Mr. Aker, thank you for having us today. Thank you for listening to this. You know, I appreciate everybody taking time out of their day to do so. I am opposed to the fence. I'm on that side. Just on Monday, I saw your city planners come out and look at it, and I went there and just kind of saw what they were assessing and just talked to them briefly. And I understand that safety, from their perception, is not a concern. So I don't want to address safety. I think we've talked about that from our side plenty last hearing and this hearing. But as a father of 2 children, 8 and 2, it is a concern of mine. And we do have 11 children in the neighborhood and a lot of young families, and I imagine there's going to be more kids, and I think that's probably why it's been such a concern for this neighborhood, is all the children. What I would like to talk about is, you know, the code, and I think Richard put a lot of emphasis in his, you know, his whole thing that he presented you. There's a lot of pictures, there's a lot of stuff, but at the end of the day, we just really, we're not opposed to them having a fence. As a neighborhood, it kind of struck me interesting that when he came up here, their attorney, their representation, he said, we tried to meet a meeting of the minds, and the first young lady who came up, she said, I'm the neighbor and nobody approached me. I think a lot of people have approached them, and a lot of opportunities to resolve this within the community have been shot down. And I think if the variance is not granted, as a community, we would resolve this. We have nothing against them. They're actually friends of the community. We want to resolve this. But if the variance is granted, I don't think we could do that as a community, because there isn't much more recourse but to, as Richard said, we want to take it to the next level. I said that you said we have the opportunity to do so. But at the end of the day, I think this could really get resolved in the community if this is denied. Thank you.
Thank you, sir. Anybody else? Mr. Moore, if I could ask you to step back forward, please. Just want to kind of understand a little bit better myself as well. So, you know, we've talked a lot about whether or not we've talked a lot about safety, you know, and I've asked you, you know, to first come up and just give me just kind of a, you know, what's your opinion type thing, but I'd like to get a little bit deeper. It's my understanding, and correct me if I'm wrong, that, you know, I don't know that it necessarily, the assessment is not whether or not there are safe or unsafe conditions. So much, so more so, the question is whether or not this fence at 6 feet as opposed to 4 feet creates additional safety. Is that a correct statement?
That's a correct statement, and that was how our analysis was based, was the variance that you're considering today from 4 to 6 feet, does that additional 2 feet create an additional safety concern? And our evaluation was that it did not.
Right, because this property owner could build a fence right now, or this fence could have been built at 4 feet, and it would have not spawned any.
That's correct.
Any need for any variance request whatsoever, right?
Correct.
So can you help me understand a little bit better the types of things when you look at, you know, when you're asked to go to an intersection, and you're professionally you're a civil engineer, right?
Correct.
So this is within your wheelhouse, okay? when you're asked to go and assess, and I've worked with you, for a long time, I know that this type of thing, whether or not there are visual obstacles that impair, line of sight issues at intersections is a common thing for you to look at. So when you go to a site like this and look at it, what are some of the things, how do you assess whether or not this additional 2 feet would indeed create more risk or not? I'm sure there's some types of the corner, and I know we're also talking about an existing wall that's there.
That's right.
So you're looking at distances to the intersection, so help me to
Offsets
better
from
understand
right
that.
of way, whether or not it's a stop condition, speeding, whether or not there's sidewalks, and we factored all of that into our analysis. And we didn't do any type of plan per se. This is all based on visual inspection. We looked, and like you said, foliage does play a role in this, but it was our opinion that the existing monument sign seemed to be more of an impediment than raising the fence from 4 to 6 feet. So our analysis was not based on a survey per se. It was just based on a visual analysis of the situation.
Right. And, when Mr. Poland was here for his presentation, he did provide a lot of documentation and a lot of photos. I know that when you guys went out to do your assessment, because we got that in our briefing packet, that you guys did some photos as well, because there was an allegation of misleading information with regard to fence height.
Right.
And while it is true, obviously, that there are portions of the existing, what we're calling the monument fence wall.
I believe you guys saw a picture that I was stood by the monument sign, and there's
so I'm looking
at least
at a
2
picture
feet.
that is at the intersection, the section of the wall that has Summer Place on that section of the wall between those columns, and you're standing with your back to that section of the wall.
That's correct.
And how tall are you?
6'1".
You're 6'1", and this is at least 12 inches higher than you in this photo. Okay. So, and that where you're standing is at the intersection, right? I'm assuming, because it says Summer Place on the wall.
That's right. Yes, sir.
Okay. Any questions for him? Okay. Mr. Stobbs, thank you, sir. There's been a lot of talk about the 4 standards that any variance request is measured by.
Sir.
So it's my understanding that there is an arguable hardship that was satisfied through your assessment when you measure these variances against.
Yes.
And
Yes, sir.
just for the record, you measure all variance requests against these standards equally.
Correct.
Is that correct? Okay, thank you. And was it your opinion, was it your professional opinion that the standard that dealt with arguable hardship was met?
Yes, sir. Because this is not just a corner lot, it's a double frontage lot.
Right.
So there's a setback distance required on Nickajack, on Summerwood, that greatly reduces the allowable usable area. The applicant has stated that a 4-foot fence is inadequate to provide safety and security. And we've acknowledged that.
Right. Okay. Any questions for Mr. Stobbs?
No.
Thank you. So, as you can imagine, if anyone here were in the position that we're in, and by the way, none of us are elected officials either. We're all staff. So the variance process obviously is in place to allow unique situations the opportunity to develop property that they own, which is kind of the basis here. What we're trying to do, and what all municipalities and counties are charged to do, is find ways that we can both enforce certain standards in a way that's legal to people that have property ownership rights and property that they own, free and clear. Okay, so or not free and clear, but property that they own. We all, as property owners here in this country, have rights to do things that we want to do on our property. And when we talk about when what we want to do is in opposition to standards, that's why we're required to have a variance process. That's why we have standards that any variance request is measured by. And I can assure you, as a 30-year employee with this city, that the Community Development Department takes the measuring of the variance requests against the set standards very seriously, and that's something that they do every single day with great professionalism. Okay, so did anybody else have any other questions?
Agree with that last statement.
Thank you. Okay, anybody else want to make any comments? Okay. Seeing none, I will entertain a motion for item 3AV 19025.
I make a motion to allow the front yard on corner lot,
Second.
I have a motion to approve the second. If there's no further discussion, I'll call for a vote. Motion is approved 3-0. As stated earlier, the decision by this board is appealable to the full mayor and council. That appeal has to be, Ms. Graham, correct me, that appeal has to be submitted in writing to you within 10 business days. Okay, and that can be done today, and it can be handwritten, right? Okay. Okay, next item on the agenda is 3B, is a public hearing variance request V19. Reduction from 35 feet to 28 feet, land lot 597, 0.17 acres, located at 3384 Vinings North Trail for Robert and Ashley Sullivan. Is the applicant present?
I'm present. I'm Robert Sullivan.
Good morning, Mr. Sullivan. So if you could just kind of give us tell us what your variance request is about.
We just purchased a house off Vinings North Trail.
Okay.
The front of the house has a small 3-foot by 3-foot stoop. We're requesting to encroach on the setback, an extra 5 feet to allow us to build a front porch on the house.
Any questions at this time for the applicant?
No.
Mr., if you could please have a seat on the front row right here. Mr. Joey Stobbs, if you could.
Good morning. Variance request V19-028, 3384 Vinings North Trail to allow front setback reduction from 35 feet to 28 feet. As the applicant stated, this house has a front stoop. Currently, the house is built on the 35-foot front setback line. The stoop is in it's currently at 28 feet from the property line. They're wanting to replace that stoop with a covered front porch to have more of a craftsman style architecture. And that's it.
So it's existing non-compliant?
Correct.
Okay.
At least that front stoop is.
Yeah.
We've analyzed the request and recommended approval with one condition. That approval, requested variance shall be conditioned upon the development of the property in substantial compliance with the site plan and elevation submitted with that variance application. Signage has been posted and neighbors have been properly notified.
Mr. Sullivan, are you in agreement with that condition? Any questions for staff or the applicant? This is a public hearing. If there's anybody here that'd like to speak for or against variance request V19-028, I would ask that you'd step forward at this time. Seeing no one step forward, I will entertain a motion.
Motion to approve V19-028, to allow the front setback reduction from 35 feet to 28 feet for land lot 597 at 3384 Vinings North Trail.
Second.
We have a motion to approve, second. If there's no further discussion, I'll call for a vote. Motion passes unanimously. Thanks, sir. The agenda C, D, and E all are three separate items that are requested by the applicant to be tabled. They all center around one project. Mr. Stobbs, I'll go ahead and call item C, variance request V19-029 to allow front setback reduction from 50 to 37.5 for land lot 809, 0.99 acres located at 2543 Spring Road, on-site civil group, Mr. Jason Stowe as the applicant. It's our understanding that the applicant has requested to table these for the future. Is that correct?
Yes, sir. All, like you said, all three are connected. We're still working out some emergency response access issues, so we wanted more time to work that out with the applicant.
Okay. Thank you, sir. This is a public hearing. If there's anybody here that would like to speak on behalf of V19-029, would ask that you'd step forward at this time. Seeing none, I'll entertain a motion to table.
Motion to table, V19-029, variance requests to allow the front setback reduction from 50 feet to 37.5 feet, land lot 809 at 2543 Spring Road.
Second.
We have a motion to table. It's been seconded. I'm assuming that, for the record, that will be to table indefinitely. We're waiting on the applicant. Is that right, Mr.
Yes, sir.
Stobbs? Okay. Motion to table indefinitely that's been seconded. If there's no further discussion, I'll call for a vote. Vote passes unanimously. Next item is related, 3D, public hearing variance request V19-030 to allow side setback reduction from 40 to 32.5 for the same property as previously stated. Mr. Stobbs, any additional information?
No, sir.
Thank you. This is a public hearing. If there's anybody here who'd like to speak on behalf of V19-030, I'd ask that you'd step forward now. Seeing none, I'll entertain a motion to table.
Make a motion to. 0.5 feet.
Second.
Motion to table has been properly seconded. If there's no further discussion, I'll call for a vote. That motion passes unanimously. One last one for the same project, variance request V19-031 to allow landscape easement reduction from 10 to 5 feet for land lot 809 for the same on-site civil group, Jason Stowe. Mr. Stobbs, I'm assuming no further, no additional.
That's correct.
Okay. This is a public hearing. If there's anybody here who wants to speak for or against variance request V19-031, I ask that you'd step forward at this time. Seeing no one, I'll entertain a motion.
Motion to approve V19-031, easement reduction from 10 feet to 5 feet at land lot 809 at 2543 Spring Road.
Just for a correction, that'd be motion to table.
Motion to table, thank you.
Yes, thank you.
Second.
Have a motion to table. It's been seconded. If there's no further discussion, I'll call for a vote. Yeah.
Okay. Gotcha.
That motion passed unanimously as well. 4A, last item on the agenda is item number 219-258, approval of the July 10th, 2019 License Variance Board meeting minutes. Do I hear a motion to approve those minutes? Motion to approve those minutes has been properly seconded. If there's no further discussion, I'll call for the vote. Motion passes unanimously. I will adjourn the meeting of the License Variance Board meeting at 10:49. Oh.